Okay, I think we are good to go, everybody. Once again, welcome to this morning's Demystifying Section 156, Type 1 versus Type 3 fire risk assessments. My name is Shauna Thornton. I'm one of the directors at Ark Workplace Risk, and I'm going to be moderating today's topic for you. So it's lovely to see the numbers. We currently have lots of people joining, a few familiar names and a few others that we don't know. So we'll get started. So I'll just do quick introductions for you for things. So next slide, please, David. So a little bit about Ark, for those of you that don't know. So Ark is one of the companies that have been working in the industry for over 25 years. And we like to see that we are a trusted partner with the clients that we work with, currently working with over 500 different brands in the industry, offering solutions and comprehensive advice to our clients. Our speakers today, first of all, is David Hills, who is our Senior Technical Director and who will introduce himself in a moment, and Kizzy Augustin, who is a partner at Mishcon de Reya. We are so delighted to have Kizzy with us. I know when I was speaking to a number of our clients over the last number of weeks, they were extremely excited to hear from Kizzy today. So we are so thankful for her for taking the time to join us today. So thank you very much, Kizzy. So a little bit about the kind of running play today. So when we will be talking about our agendas, David will go through the introductions. We'll then pass to Kizzy, who will go through changing the culture right through to the impact of HRBs and the safety case reports. David will take us then through the types of fire risk assessments, testing of competencies and type 3s in your safety case reports. And at the end, we will take time for questions and answers. The questions I will moderate at the end, so please do send them in. And to get us started, we're going to kick off with a poll. So the poll we can see is something that we would love for everybody to take part in. So the question at the moment we're going to ask to everybody is, as a managing agent, for owners, what type of fire risk assessments have you undertaken for your higher risk residential blocks? So we would encourage everybody to provide an answer for this. The reasons why is you won't be able to see the answers and the percentages unless you take part. However, I will provide you with the update of that. So we'll give you a few moments to answer the poll, and we can go then to our results. So the responses are just coming in. Very interesting, the responses as they're coming in. We currently have 66 responses to the poll. Based off, so this is for David and Kizzy, for their understanding so far. So the question again was, as managing agents or owners, what type of fire risk assessments have you undertaken for your higher risk residential blocks? 32% have said that an assessment that only covers the common areas of the buildings undertaken in a non-intrusive manner. 8% have said an assessment that only covers the common areas of the building but includes a degree of intrusive elements. 39% is an assessment that covers the common areas and has a sample of tenanted. And 22% so far has said an assessment that covers the common areas of the building, tenant areas, but includes intrusive inspections. So a broad mix, but at the moment, type 3 element seems to be the leading, which is good. So thank you, everybody. So David, over to you to get us started. Thank you.
Okay, thank you very much. Just really want to set the scene before we ask Kizzy to take over. The response from the Grenfell fire back in June 2017 has been, or is now, a reality for many of our clients and many of you as well, with many of you being asked or being directed to submit your safety case reports and other documentation as part of the building assessment certificate. Effectively, we're seeing now that new framework for managing safety being implemented in real time. So it's going to be a very interesting time, because obviously we've got a growing emphasis on ensuring the safety of buildings and their occupants. And from that whole new framework, we can see that we've got new regulations that are aimed at preventing incidents and accidents. We've got enhanced overall safety standards, which are still growing. And of course, the main aim of the Act as well was really to hold people to account. So we're ushering in now that new era of accountability. And we're seeing now the need for a change in the culture of the whole of our industry, from design to construction to management. Central to that new framework, effectively, we've got risk assessment. And effective risk assessment is going to be so vital for ensuring that not only are you meeting the requirements of the Building Safety Act, but other legislation as well, which Kizzy will go through with you. Historically, there have been a number of issues in respect of fire risk assessments. And in addition to that, we are seeing a significant amount of conflicting advice and recommendation coming from either local fire authorities and or the regulator as well. Effectively, we've got two new regimes, and Kizzy, I know, will take you through where and how those two new regimes actually operate. Effectively, what we've got, or what we have seen in the past, is what Dame Judith, in her report Building a Safer Future, actually called a race to the bottom. Most people were selecting, clearly not according to our poll, but still 33% of people were deciding that type 1 fire risk assessments, for example, which are generally cheaper than the other three types, have been accepted and been used, mainly because in many situations, fire authorities have in the past turned around and said very clearly that they are perfectly acceptable for meeting their particular requirements. So with the introduction of this new framework, we are now seeing that conundrum, those conflicting areas. And so we want to today go through that, and that's exactly what we're going to be looking at. And it has been exacerbated as well by the introduction of Section 156 of the Building Safety Act, which actually has amended the fire safety order. So to help us to go through this, I'm very, very pleased to be joined by one of the UK's foremost health and safety lawyers, Kizzy Augustin from Mishcon de Reya. She's going to be taking us through and unraveling this conundrum. I've no intention of taking any more of Kizzy's thunder. So, Kizzy, over to you.
Thanks, David. I do love it when people introduce me. I think it's such a nice thing to do, and say nice things about me. So I hope I don't let anybody down. So yes, I mean, as David said, my job is to maybe highlight some of the things that people on this call already know, but maybe give a bit of insight as to what's been going on in the legal world, dealing with a new regulator or kind of revised regulator, but also dealing with two regimes and what is expected of those people that have accountability. I'm really sorry, I'm going to have to do next slide all the way through, but I shall do it and stop apologizing for it. So one of the things I wanted to maybe get across to everybody on the call was this idea of a change in culture. To be honest with you, those of us in the health and safety, fire safety, and even the legal world have been talking in the language of prevention, proactivity, accountability for some time. And it's been helped by the fact that Judith Hackett went through her review of the regulatory climate, and the changes that have taken place, including all of the legislation that's come about, has really shown us the focus on high risk activities, such as those who are involved in construction work, those who are involved in property management, and other high risk sectors like agriculture and manufacturing. But the focus has been very much for the last 2-3 years on buildings, those that are occupying buildings, those that are creating and managing buildings. And that's been a factor for us. In doing that, there has been a historic approach to think that if you are using consultants, advisors, third parties to help you be compliant with your regulatory requirements, then in some way you are not divesting the responsibilities. I think in the past people have thought if we've got external people coming in, they are taking on the responsibilities. What we do have to remember is in using third parties to help you be compliant, like risk assessors and consultants, you are simply asking those people to help you as a primary duty holder to comply with your obligations. They also have their own obligations, but it's the remembrance of this is a way of helping us comply with our ongoing responsibilities. The targeted enforcement action and the approach, particularly from the Health and Safety Executive, has meant that you have got to be really focused and on the front foot, especially if you are involved in property management or the use and occupation of buildings, because the consequences for getting it wrong now are pretty dire. We had the introduction of things like the health and safety sentencing guidelines, which meant there were much higher fines if you were non-compliant with your responsibilities. The Building Safety Act further exacerbates that in terms of it being another regime where high fines and other consequences could be imposed for non-compliance of things like a failure to have a suitable and sufficient risk assessment or a failure to comply with building safety and fire safety requirements. David talked about this idea of accountability and the introduction of the Building Safety Act being all about accountability, and it truly is in the wake of Grenfell. But what we also are seeing is this split between what corporate accountability looks like and what I would say is almost more important, the personal accountability side. So we'll come on to talk about responsible persons and accountable persons, but it's the idea of this not just being a corporate duty or a corporate accountability issue. Every single individual who has legal obligations by virtue of either the Regulatory Reform Fire Safety Order and or Building Safety Act can and probably will be held personally accountable as well. So why be proactive? Why listen to me? Why listen to to Ark? Why are you here today? Why are you wanting to be proactive and preventative in your approach to compliance? Well, there are a number of reasons. One is that the financial side and the sentencing guidelines that I spoke about, because the fines are quite high for getting it wrong, but also you have that legal obligation, which is the bit I'm going to focus on a little bit today, but also the contractual obligations that might be set up between owners, freeholders, landlords and other third parties such as leaseholders and tenants, and the moral obligation. I don't think anyone on this call, despite what type of duty holder you are, would want people to be at risk of injury or worse still because of a non-compliance issue. And that's actually why I think it's really important for everyone to be proactive and preventative in their approach to the mitigation of fire risk. Next slide. Okay, so this hopefully will be a refresher for everybody. I've simply put up who are the duty holders we're talking about and why are the changes in respect of building and fire safety so important. We already know about the existence of a responsible person, that being defined by virtue of the Regulatory Reform Fire Safety Order. I'm not going to say that again, I'm going to say RRO from now on, and all about the personal liability surrounding what a responsible person has to do. It's generally going to be the owners and the employers of buildings, the commercial aspects of buildings, and if you're dealing with residential buildings, then it will be the common parts of those buildings that you are concerned with and that you have a responsibility for. I'll come on to what we mean by common parts in a moment. What the RRO helpfully does, and we've now sought clarification about that, is are there other responsible persons that also have an obligation to do various things in accordance with complying with the relevant fire safety legislation? And there are. So there are those wider RPs that are defined by virtue of the order as any person who has control of that building to any extent, so far as the activities or the requirements they're required to deal with are within their control. And what that means is if you have something like a contract or a tenancy or an agreement that gives obligations in respect of maintenance, repair or safety, then you too are likely to be a responsible person for the virtue or under the Regulatory Reform Fire Safety Order. It's important to remember that that's a fire safety obligation. And there are corresponding corporate responsibilities which talk about taking general fire precautions so far as is reasonably practicable to ensure safety of employees and safety of non-employees as reasonably be required, very similar to health and safety legislation. So that's fire safety. Next slide. Oh, there we are. So what's changed? What is different? What did the Building Safety Act bring? Well, I'm not going to talk about the whole of the Building Safety Act because we could be here all night, but we have got three things that I think are really relevant to those who are involved in the mitigation of risk, particularly fire risk in buildings. We have the Fire Safety Act, we've got the Fire Safety England regulations, and then we've got section 156 of the Building Safety Act. In essence, the Fire Safety Act gave clarification for the areas that a responsible person is responsible for. The Fire Safety England regs gave us specific details on the things that would be expected from certain buildings of a particular height. And then section 156 talks about changes to the RRO. So if we go to the next slide, I'll again give you a bit of a summary of those changes. Again, these are things that I hope people on the call already know, but the Fire Safety Act gave clarification as to the scope of the RRO when we are dealing with a multi-occupied residential building. What do we mean by the common parts, essentially? In the past, there's been some discrepancy as to what is a common part. It's the stuff that we knew, like the hallways, the staircases, but certain parts of a building used to be subject of maybe some dispute between landlords and leaseholders, or landlords and tenants, where they say the lease doesn't say that, so therefore we're not responsible for it. What the Fire Safety Act has sought to do is clarify what those obligations are. So as it says on the slide, the RP is responsible for the building structure, external walls, and any common parts. The external walls includes things like the doors and the windows in those walls, and anything attached to the exterior of those walls, like balconies and cladding. And we can remember there was a whole furore about responsibilities in respect of cladding just after the Grenfell fire. It also includes the doors between the domestic premises and the common parts. So again, it's being distinctive as to what you are required to mitigate in terms of risk to the common parts of those buildings. And all of that would require an update of a risk assessment because it would qualify as a significant change to circumstances. So that's Fire Safety Act. Next slide, we focus on Fire Safety England regs. Again, I'm not going to go through this in lots of detail, but you'll see from this slide there are further requirements that are being imposed on responsible persons when we're talking about all buildings. And I'll focus on the all buildings part because this is the bit that highlights what extra information needs to be gathered as a result of your own legal responsibilities. The Fire Safety England regs specifically says for all multi-occupied residential buildings that have 2 or more domestic dwellings, you are required to provide clear and relevant fire safety instructions to residents and provide those residents with fire door information. Now, it's anticipated that that was being done in any event, but in terms of having a suitable and sufficient risk assessment, as long as you've got a good risk assessment in place that's being prepared by a competent person, and again, we can talk a little bit about competence later on, you will have the necessary information to then comply and, with these obligations under the new regulations. So it is really about what type of information are we getting? Are we getting the right information in the first place? And are we sharing the right information with those that need to know? So I think the Fire Safety England regs have been really good at specifying that. You'll see from the others, you know, buildings over 11 metres, you have additional checks. Buildings over 18 metres or 7 stories or more, those higher rise, higher risk residential buildings, again, have a prescriptive list of things that need to be covered. So again, I won't do that, go into detail on that today, but you can see the amount of information that is required is now more extensive than it used to be under the original RRO. Next slide. And then we come to section 156, which again is a big focus for us today. what Section 156 of the Building Safety Act has done has changed things in terms of what the RP is required to do, particularly in respect of fire risk assessments. Now, the requirements under Section 156, which changes the RRO, applies again to all non-domestic premises, including workplaces and non-domestic parts of multi-occupied residential buildings, all the bits that I talked about under the Fire Safety Act. And it could be slightly deceiving to think that when we are talking about risk assessments, because the RRO talks about common parts only, and the guidance for Section 156 also talks about non-domestic parts of multi-occupied residential buildings, that maybe the type 1 type of risk assessment that was referred to earlier is all that matters. All I'll say to you at this stage is maybe have a think about what I'm going to talk about over the next few slides and come to your own conclusions as to whether or not you think that would suffice in light of this new world that we have. So in summary, Section 156 talks about what the RP is expected to do in respect of fire risk assessments. And what it will do, I'll focus a bit on the fire risk assessment on the whole, and also a bit around collaboration and cooperation with others. But what Section 156 does is it says you are required as an RP to ensure that the completed fire risk assessment is recorded in full, whereas previously it was only specific information or significant information that was required to be recorded. It's requiring that all RPs record the identity of any individual, as in their name, details, and if applicable, their organisation that's been engaged to undertake that risk assessment or to review any or all of the fire risk assessment, and share that with residents of multi-residential unit premises where applicable. Section 156 goes on to talk about the requirement that all RPs must record their fire safety arrangements, i.e. demonstrating how fire safety is managed in the premises. They're requiring that all RPs record their contact information with a UK-based address and share that along with identified fire safety risks, preventative and protective measures, and any competent person that's been nominated to assist with firefighting and detection measures with other RPs and residents of the relevant premises in question. It goes on to require that all RPs take reasonably practicable steps to ascertain the existence of other RPs, those wider RPs that we've talked about, that may have duties in the same premises, and accountable persons. Now, accountable persons, which is essentially the new legal entity that was created under the Building Safety Act in the cases of higher risk residential buildings, those 7 stories or more, 18 metres or more, in relation to the premises. Those accountable persons, it's a new concept, or has been a new concept for a while, where we're talking about those that have either legal ownership of the building, or if they don't have legal ownership of the common parts of that building, then they have what's known as a relevant repairing obligation. I might come back to that in a moment because there's some discrepancy as to whether or not managing agents, property managers, etc. could fall into the category of an accountable person by virtue of that relevant repairing obligation. But I'll pause, maybe remind me about that if I haven't come back to it after we've gone through Section 156. Just finishing off on 156, it also requires that this idea of cooperation and collaboration, which is something that's not a new concept to us in the legal world. Things like the construction design and management regulations talk about cooperation and collaboration. The fire safety regulations, RRO, talks about exactly that same thing. So this is not new. The Section 156 changes also require that any departing RPs share all relevant fire safety information with incoming RPs, and then also requires those RPs to provide residents with the similar relevant fire safety information. So that's quite a lot. It's quite a lot to take on board, and it's quite a lot that requires relevant and accurate information to be provided. The question is, how do we gather and obtain that relevant information? Next slide. I think David mentioned at the beginning around this idea of two regimes, and I've just spoken to you about new legislation that's been introduced to amend our existing understanding of the relevant fire safety legislation. And the focus very much is on recording your fire risk assessment and other information, recording it in full, making information available as much as possible, or much as practicable, maybe we should say, about fire safety in the premises. Now, all of that's quite important, but I think what's also very important to think about is this idea that this is a two regime process. The Building Safety Act is a regime on its own. So as much as Section 156 has changed the RRO, we have to remember that these are two regimes that it's hoped will work in tandem with each other, or they'll complement each other. In reality, what we're seeing, and certainly what I'm seeing from clients, is there's a real difficulty in combining the two. And what we're finding is maybe the secondary legislation that comes in will help with some of that and help with the understanding. But in essence, you may well have 4 different regimes. I'm talking about 2 here, but you may have 4 regimes that will require compliance. The Health and Safety at Work Act, looking after employees and non-employees. You've got the fire safety legislation, RRO, as we've talked about. You have got potentially construction design and management regulations if there's any works being done, and there may be duty holders as designers or contractors or someone who's managing a project. And now you've got the Building Safety Act. That's 4 regimes that have to be complied with. And I would say that gives regulators 4 bites of the cherry to look for or potentially enforce non-compliance. But what I think you might be able to have some influence over as duty holders is this idea of cooperation and collaboration. And I'm going to talk about that in the context of 2 regimes that I really want you to remember. So Article 22 of the RRO talks already about the collaboration and cooperation of duty holders, of RPs. This idea of taking steps that are reasonably practicable to ascertain whether any other RP shares or has duties in respect of the premises. And this is part of the kind of change as a result of Section 156. It's this information gathering, it's the information sharing, informing other RPs concerned of names and address details of the RP, and informing other RPs concerned of the part of the premises for which they consider themselves to be an RP, and keeping a record of that information. That requires interaction, that requires an understanding of different parts of the building, which might be outside of your own RP demise. But it is very much focused on the common parts under the wording of the RRO. Switch now to looking at the Building Safety Act and what that might say about the requirement for accountable persons. So new duty holder, new regime, slightly different wording. You'll see similarities in respect of Article 22B, which is a new provision, and it mirrors Article 22 to some extent in respect of imposing this duty on RPs to take such steps as is reasonably required or is reasonably practicable to understand and ascertain whether or not there are more than one person in place who is an accountable person. So that's a new duty holder. And if there are, the RP must cooperate with each AP, accountable person, for the purposes of that accountable person carrying out their duties under the BSA, for which that is extensive. Accountable persons and principal accountable persons, which is essentially the accountable person who has responsibility for the external part of the building or for the structure or the structure or exterior of the building. There is a lot of things they have to do, including the creation of safety case report, including creating a resident engagement strategy, including all of the things that are required to report to the regulator, such as registration of buildings. So information is required for the AP to be compliant with their obligations. The additional thing to consider under the Building Safety Act is the purpose of this requirement to liaise and engage and cooperate is to ensure that RPs and APs take what the government guidance for the legislation talks about as a whole building approach to building and fire safety in higher risk buildings. This will make sure that things like the golden thread of information required for occupied higher risk buildings is complete, and the information contained in the safety case reports, which I'll talk about on the next slide, will demonstrate the effective management of building safety risks. So it isn't just, let's just do our bit. It's really about looking at the whole building approach to the mitigation of fire safety risk. And that is, I think, where the real differences lie. We also have to think about the fact that we've got two regulators in place, the Fire and Rescue Authority, who deal with fire safety enforcement, and the Building Safety Regulator, which is a new regulator, part of the HSC, but deals with building safety. So these are real differences that I think duty holders have been grappling or trying to grapple with for the last couple of years. Next slide. And just to touch on this idea of information and how important it is, again, I'm making reference to safety case reports and looking at, well, I cannot tell you what a perfect safety case report looks like, just like I can't tell you what a perfect risk assessment looks like. But when we're talking about higher risk buildings, this idea of the 7 stories and 18 meters high, there's the requirement for the principal accountable person to prepare a safety case, or to kind of draft a safety case and summarize that in a safety case report, which by virtue of the wording identifies the building's safety risks, not just common parts, but the building's safety risks, and explains how those risks are being managed. Building safety risks, as we know under the Building Safety Act, is all about the risk of the spread of fire or the structural failure in any higher risk, higher rise residential building. To me, that smacks of it being more than I am only required to understand and know about the risks that affect the common parts of the building. Fire risk, the risk of the spread of fire can touch on the internal parts of a tenant's demise, for example. So I think having an understanding of what risks occur on the other side of the tenant's door may well be important for building safety compliance. And also, there's a talk about using all reasonable steps to ensure that there is this mitigation of fire safety risk. And it also talks about looking at the way in which you obtain that information, using all reasonable steps. Slightly different from the health and safety world, where we talk about reasonable practicability. This is now talking about all reasonable steps. Is that very different from the reasonable practicability point? We're not quite sure, but I think I've definitely heard from a representative from the regulator that it will be taken as if you were doing this in a health and safety context and using your reasonable practicability to mitigate the relevant fire safety risk and prevent building safety risks from happening. And the way in which you do that is through risk assessment. Yeah, it's provided by each AP. You provide the significant findings or all findings in respect of the changes of the assessments, and you provide a summary of any recommendations and action plans. To me, you can only really do that in a holistic way when you are looking at the whole building and the risks that affect even your own demise. Next slide. So to conclude, it's not all depressing. And it doesn't mean that because you've got onerous responsibilities, of which they are, and they are quite onerous, it doesn't mean you can't comply. And it doesn't mean you must do things miles different to what you were doing. But I think having an understanding of what the risk of liability to your organisation or you as an individual, you as a duty holder might be, that includes consultants too, is really important. Understanding the risk of high fines and or I'll say imprisonment, and I know that's quite scary, but for getting it wrong, I think what we're seeing now is much more of a focus on personal accountability. So breaches of the RRO in the past have focused very much, and it's an easy win for regulators, a failure to have a suitable and sufficient risk assessment in place. Compare that to now the new powers under the Building Safety Act, where A failure to have building safety risk assessments in place can be punishable by an unlimited fine or up to 2 years imprisonment, very similar to the health and safety regime. The personal liability for an officer. Who is an officer? Well, I've said it on the slide, but I think it could be a very wide interpretation in time. Failures to comply with your obligations under the BSA can include things like a failure to conduct a building safety risk assessment for a higher risk building, a failure to complete a safety case report, and actually that should be on the next line, but having an effective system for managing risk. So it really is all about the information on the relevant risks in the building and having that whole building approach. I think, to leave you with a proactive and a preventative and robust approach to the mitigation of fire risk is key, and you've really got to use all reasonable steps to mitigate fire safety risk. And what is reasonable? Well, using the tools that you have to create a suitable risk assessment and utilising the advice of competent consultants.
Thank you very much, Kizzy. Really, 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 really interesting. And it's great to actually hear a legal point of view. I'm going to spend the next few minutes just taking you through what the different types of fire risk assessment are, how we can test for competency, and then talk very specifically about how fire risk assessments can actually support safety case reports based on the experience that we have of actually writing those safety case reports for a number of clients. And as Kizzy said, quite rightly so, these haven't been tested yet, but we're certainly going to be interested into seeing how the regulator takes that on. So why are we talking about the different types of fire risk assessment? Well, there are currently 4 different types of fire risk assessment, and we've got a brand new code of practice that is coming out. It's out for a consultation at the moment. This brand new code of practice, BS 9272, is all about trying to replace the old PAS 79 Part 2 version, which has been criticised fairly or unfairly. It depends upon your view. But basically now we're going to have a new standard, and that's going to set out in principle the 4 different types of fire risk assessment. Now, the extent to which those are applied to a building really does depend upon the extent of the inspection and the use of certain intrusive methods. So a type 1 fire risk assessment deals with the common areas only and is non-intrusive in nature, whereas a type 2 deals with exactly the same areas, the common areas alone, but is intrusive in nature. And what we mean by intrusive, we mean obviously breaking into or opening up certain parts of the construction. A type 3 assessment looks at your common areas and some of the demised areas. It doesn't have to cover all of them. A reasonable sample will be perfectly acceptable, but is non-intrusive in nature. And then a type 4 is a common area and demised area again, but is again more intrusive. So let's just delve a little bit and unpack those a little bit more. So what does a type 1 fire risk assessment deal with? It's a basic assessment. It's designed for the purpose of satisfying the fire safety order, and it relies upon the duty holder having a good comprehensive understanding of the fabric of the building. It covers, as I've just mentioned, the common areas only, so the means of escape, any plant rooms, risers, and shared areas such as car parks, lounges, for example, in BTR, all those types of areas. Now, as I said, it's non-intrusive in nature, but it has to include a sample of the flat entrance doors, especially as we have changes under the Fire Safety Act as well. Riser cupboards, we should be looking at roof voids as well. And it should be at least considering the separation construction between the common areas and the residential demise areas without undertaking any opening up of the construction. So it's really identifying any obvious breaches of compartmentation or separation. And in addition to that, it must include consideration of your external wall and any attachments to that external wall. So type 1 is relatively simple. Type 2, I will whiz through this particular part again. It's very much like a type 1 assessment. It covers the common areas, but it can include a sample of the tenant's demised areas. And this therefore includes as well getting into those roof voids, but actually really opening up the construction in respect of the walls and the separation between common areas and residential demises. So that's the real big difference between a 1 and a 2. Type 3 assessments, and I just want to spend a little bit more time on type 3 assessments, really cover the whole building in line with both the BSA guidance and within the code as well. So it covers the whole area, and the way it does that by looking at a sample of the dwellings, or if you have got commercial users, a sample of the commercial areas as well. It's non-intrusive nature, but again, it covers certain particular parts such as the flat entrance doors, the roof voids, and any other common areas, as well as the external wall and attachments. I think the other element it's worthwhile thinking about here is that whilst we are going into a residence demised area, we are not looking at the whole aspect of fire safety within that residence demised area. There is a perception by many that, oh, why are we taking responsibility for the other parts that we have no responsibility for? Well, the idea of a type 3 assessment is really just to make sure that the integrity of the fire resisting elements, the walls, the floors, the ceilings, between the dwellings themselves is there, that we are not dealing with excessive travel distances, that the protection of hallways is there where it's relevant. Clearly studio flats are slightly different. And how easy is it to actually open the entrance doors? It's also to consider as well about the fire safety in the inner rooms, as well as means of escape from areas such as maisonettes, as well as looking at the electrical and heating installations which are provided by the duty holder, the owners, rather than the tenants, as well as making sure that sprinkler systems and water mist systems are operational, and as are smoke and heat detectors and alarm systems. So type 4 risk assessment takes that to another level. Again, we're looking at the whole building plus a sample, so the common areas and a sample of the dwellings. The degree of intrusive inspection really starts to get into looking at and breaking into the walls between the individual dwellings. Now, more often than not, this type of assessment is really not a welcome one, especially in existing buildings, because nobody wants to break open a wall, and therefore, you know, the most intrusive elements of it are very unpalatable to most. So a lot of people are very wary about doing this, but it is worthwhile thinking about it, as it's a very comprehensive fire risk assessment, and it's most often used when there is actually a reasonable reason to suspect that you have got some serious risks to the residents themselves from both fires in their own particular demised and dwelling areas, or a fire in a neighbour's dwelling as well. And we are tending to see that most people who take on a building for the first time are undertaking a type 4 fire risk assessment first, before then moving to a lower one, such as the type 3 assessment. Kizzy mentioned competence, and so I just really want to quickly go through competence now, and how we can test that competence. And it doesn't matter who carries out your fire risk assessment, duty holders now have a particular set of responsibilities. And those responsibilities are to make sure that anybody who is working on, in, or around your building is competent to do the job that they are engaged to do. So accountable persons now, supported by perhaps other responsible persons, need to be very, very clear and check the competency of those who are going to be undertaking the fire risk assessments. In fact, the regulator and the government have indicated that over the coming months they are intending to issue some guidelines on competency, and there may even be additional changes in respect of secondary legislation. So the first thing that we would suggest while you test competency is be very clear about the scope of the work that you're carried out. Make sure that when you are quoting or asking for quotes, that you're getting the same area, and make sure that the assessors are going to provide you with effectively an informed quotes so you can draw the proper conclusion. And you need to make sure that you are satisfied that the fire risk assessor who's going to carry out the work is competent. And how are you going to be able to demonstrate that? How and what evidence are you going to have of that will actually support that? You need, therefore, to be asking for evidence from your fire risk assessors that they have, for example, continued membership of a certification or accreditation body that can support demonstration. It's not necessary, it's not a legal requirement at the moment, but it's certainly one way that you can satisfy that the team that you're working with is competent to do so. You should check that the assessors themselves have experience of working on your type of property and or your type of business. And again, you need to ask for evidence. I would suggest going forward, it's a good idea to ask for references of previous clients, especially those who have worked in or are working in a similar premises type. And again, ask for proof that as well they have sufficient professional indemnity insurance. It's really, really important because we are seeing that in some instances, consultancies do not have, for example, indemnity insurance that allows them to report on external walls. And as Kizzy made it very clear earlier, the suitability and sufficiency of your fire risk assessment has to ensure that external walls are actually covered, external walls and other attachments as well. The last thing I just really wanted to talk about on this particular slide was to actually make sure that you maintain those records. Keep a record of the steps that you took, because that is going to be evidence as part of your golden thread. And if you are dealing with a safety case report, you will need to actually ensure that you've got that type of information. I've no intentions of taking you through this, but there are lots of codes out there. There are standards that all point to certain competency frameworks, and there are a number of schemes for accreditation and certification out there that you may wish to consider. Okay, last thing then, I just really want to quickly then go through the role of the fire risk assessment in the safety case report, based upon the experience that we have of writing a significant number of safety cases for our clients. One of the things that we always look at is that the terminology that's used in the guidance. So when you look at the Home Office and the regulators guidance, it states very clearly that the safety case report has got to be based on looking at and considering the measures in place to prevent and mitigate building safety risks for the whole building. Going back to what Kizzy was saying there, it's a whole building approach that we need to consider rather than just the common areas. In addition, the guidance then goes on to say that it's really vital that your fire risk assessment and any other fire safety measures you take as a result align with and complement the fire risk assessments and fire safety measures for the rest of the building in order for you to be able to provide that whole building approach. And then the guidance issued by the government on section 156 makes it very clear that the purpose of the requirement is to make sure that the responsible persons and accountable persons take a whole building approach. So we can see that the guidance that is out there very, very clearly talks about this whole building approach. So in order to support and complement your safety case report, and therefore the justifications and the claims that you make within it, your fire risk assessment has really got to look at 5 very key areas. First things first, ensure that you have a full and proper check of the whole property. Do you have suitable coverage so you can look at all of the risks for your building? You need to therefore make sure that the fire risk assessment has a full and detailed justification. It's got to include commentary. It can't just be a tick box. It's got to actually provide us with evidence as to why a particular situation is either satisfactory or unsatisfactory. What particular fire safety measures are in place? And as Kizzy turned around and made it very clear, section 156 means that you need to ensure that all fire safety arrangements are included. It should provide a full technical consideration where possible. It's got to consider all areas of all of the fire safety systems. Fire safety systems may be included within a tenant's demised area. They may not be linked to the areas or the systems that are included in the common areas, but you've got to include all fire safety systems that apply within that building. You've got to include everybody who is affected by the risks. It's very interesting. We read a fire risk assessment as part of a safety case report, that actually basically ignored the fact that a residential block containing 60 flats, the fire risk assessment covered the common areas and said that there was no sleeping risk in that building, even though we know that there are very clearly, because the assessor was only assessing the common areas. And again, we need to make sure that we take into consideration not only the fact that we've got people in there, but the number of people and any particular concerns they have. So just to end this particular part then, it's really crucial because the safety case report relies so heavily on the fire risk assessment. One of the key elements is to actually make sure that we have full and detailed understanding of the risks associated with that building. And it needs, therefore, to cover the whole building. Type 3 fire risk assessments, in our opinion, whether we provided them or not, do delve deeper into the specifics. They do allow us to see how the building is not just being, it allows us to see how the building is actually being used in real life, rather than the fact that everybody believes that a resident is going to act in a particular way. It does provide support. It does help with that in-depth analysis. It does help justify the safety within the buildings, as well as identify potential weaknesses which could compromise the safety. As I said, it details and provides full consideration of the actual occupancy in use. And again, it allows that understanding. And at the end of the day, it's that understanding that's the key element. So just really wanted to highlight some of the things that we have found, certainly in a number of fire risk assessments that we've undertaken in the last 6 months. So, for example, we did a risk assessment of a residential block that had commercial tenants on the ground floor. And in one, they had a DIY stroke home care or homeware commercial unit on the ground floor. We found when we entered that as part of the type 3 assessment that actually it was being used to store significant numbers of pressurized butane bottles. Now, if a butane bottle explodes, that's going to have a significant impact, not just on the actual commercial unit. It is going to impact the whole building. And therefore, it's so important to actually understand that, and therefore to work with that other responsible person to deal with that risk. We went into another block, for example, and we found that a resident was running their own business from their apartment, and they were including in a couple of their bedrooms, they actually had a huge amount of storage of materials, and they were shipping those materials from their own property. Included in that, though, was a whole room which included pressurized hairspray. Pressurized hairspray actually contains isobutane and isopropane. Butane and propane is a flammable material, sorry. So we need to start being considerate about that particular situation. And again, this is not going to be any news to many of you. We've been into so many assessments where we've been and found that residents, for example, have made changes to their demise. They've covered up or were removing fire and smoke detection systems, painting over sprinkler heads, and removing fire door closers. Or in one flat, for example, they'd actually removed the entire fire doors and got rid of them for their particular unit. So to conclude my part, and then I'll hand you back to Shauna. There are 4 types of fire risk assessment. They do differ. We have to recognise as well that there are 2 regimes with 2 enforcers. We have to recognise that type 1 assessments are and will be accepted by fire authorities, but the Building Safety Regulator is looking for a whole building approach. We would suggest you need to be very clear about what objectives you are looking for from your fire risk assessment. So really clearly define your scope. Confidence in the actual assessor is important. Therefore, you need to make sure that competence is what they have. You can look to third-party certification schemes to support that process. Check their insurance, and again, just accept the fact or understand the fact that Type 3 risk assessments delve deeper into the specifics, and they will be more supportive of your safety case report process because it covers the whole building. Shauna, over to you.
Brilliant. Thank you, David and Kizzy, for a very informative webinar. I'm conscious of time, everybody. I know it was supposed to be in the diaries for 30 minutes, but I think kind of hearing from Kizzy and David was really good. We have a number of questions that have come in. So what we would hope to do very quickly for those of you that are still with us is to run the same poll again. So we want to find out if, based on the presentation from both Kizzy and David, has your opinion changed on if a type 1 versus a type 3 is required? And after we run these results, we will quickly go through the number of questions that have come in for us. Any that we do not get to, we will be able to provide them to you at a later stage. I know a few questions have come in regarding the webinar. On request, absolutely, we will be able to provide slides and a copy of this recording to you. So if you can hit the results, and then we can start to take a look at the questions. So big difference, I think, from the previous results, which is really interesting, which is good. So it was 40% on the previous, and after we are at 66%. So definitely a change with everybody. So Kizzy and David, we can get started with questions if you don't mind. So Kizzy, the first question that has come in was very much based around when you were discussing section 156. So I'll start with you and David. If there is obviously some anything that you would like to say, please do join in too. So with regards to section 156, Kizzy, you did mention regarding full findings of a fire risk assessment. What do you mean by that when you're saying that the fire risk assessment has to identify full findings within that compared to significant findings before? Yeah.
Okay, so I mean, the guidance is fairly clear on what they mean. So they're saying record your risk assessment in full, and the fire safety arrangements for the premises in all circumstances. And what they mean by that is making available as much information as possible about fire safety in the premises. It's talking about not just recording the risk assessment and fire safety arrangements, but recording the information as if, you know, it doesn't matter how many are occupying, you make sure that there's a clear record who completed the assessment, so you can share the information with all the relevant people that you need to share it with. You ensure that you're talking about the whole circumstances of the risks that have been identified, as well as the control measures and mitigation for that. So you give it a common sense approach, but what they're saying is you used to be able to maybe prioritize risks and then only put down significant findings, again giving significant a common sense definition. Now it's about all your findings as a result of that risk assessment, your walk rounds, your audits, your etc., and including what mitigation is being put in place to address those risks that have been part of your findings.
Thank you, Kizzy. David, anything to add on that one?
No, I would just add, obviously, on that last part, what we look to do is to actually ensure that we are recording everything that we have seen, and we are justifying it. So we're not just saying that a property has a fire door. Okay, well, whoop-de-doo, it's got a fire door. What type of fire doors, if we can determine that? Where are they? So for us, that's what detailing it in full. It's not just stating something has got, a building has got something. Why has it got it? And what does that do in respect of fire safety?
Brilliant. Thank you. David, this one I think to you, because we can come for an update after. But David, if part of the safety case includes having a compartmentation survey, then would there also be a need for either a type 3 or a type 4 fire risk assessment?
Okay, there's a long and a short answer here. I'll deal with the short answer. There is no requirement for safety in a safety case report in every building to have a compartmentation survey. It may be that you've already got the information that actually tells us that the compartmentation is good. We would always recommend a minimum of a type 3 fire risk assessment, because that is going to deal with all of the buildings and deal with a really good sample rate of the areas of the buildings, so we can consider the compartmentation between both residents and the common areas, and between residents themselves. If you do need a compartmentation survey, that's fine. That can be therefore identified within the safety case report. It may be that you have to submit your safety case report before you've actually got that compartmentation survey completed. Great, that's not a real problem, as long as we've actually got a very clear, definitive plan that we are seeking that information. But it's interesting that a lot of people do have other parts or other types of information. If you are lucky enough to have information relating to how the compartmentation was designed and developed and constructed during construction, then again you can rely upon that rather than having to undertake a very expensive compartmentation survey. If though you need to, then a type 4 assessment is going to be of help and assistance through that process. So again, there is no definitive answer. It really does depend upon each individual. Each building, sorry, is specific to them.
Brilliant. I'm conscious of time, so Kizzy, I'll go to the next one for you, if you don't mind.
Sure.
Is there a difference between tenants and leaseholders?
Yeah, well, there is in legal contractual format. So you might have commercial tenants who are simply renting property and have a tenancy agreement. You may have leaseholders who are actually on the lease of a building. And actually, that's quite an important distinction, because under the Building Safety Act, leaseholders generally are the ones that are protected, and they are named by virtue of being able to complete leaseholder certificates, etc., and entitled to have information about the risks in the building. Tenants could relate to anyone who is renting a space in the building, but may not necessarily be on a lease and therefore a leaseholder. So there is a slight distinction. If the question is around, does the Building Safety Act protect leaseholders and tenants, I think most clients of mine are taking that holistic view that actually leaseholders and tenants are equated. So if that's probably what they wanted to know.
Yeah, brilliant. Thank you, Kizzy. David, second last one for you. Should type 3 assessments be utilised on 11 metres plus buildings as well as 18 metre plus buildings?
My personal opinion, and certainly the opinion of us at Ark, is to go back to what Kizzy was talking about right at the very end of her slides, and that's to take a proactive approach. And we certainly have recommended it for certain buildings. Is it a legal requirement? No, it's not. But we certainly make recommendation that it's a good idea to have it. And very interestingly, what we have seen is a number of fire authorities on buildings. One, for example, we had a client that had a 2-story block of flats with 48 flats in it, which had a number of fire risk assessments undertaken, who then received a notice from the fire authority asking for a type 3 fire risk assessment because it didn't deal with the tenants' demised areas. With that in mind, we would certainly recommend to everybody, take the risk proportionate approach, take a proactive approach, and a type 3 assessment will provide you with a far greater level of detail and assurance in the long run.
Can I just add one very small point in terms of what I think is happening, what's going to happen in the next year or so? There is talk of consulting on the scope of buildings what buildings will come into scope. So at the moment, yes, you've got the distinction between the all buildings, 11 metres and 18 metres. I think there is genuine scope for other buildings to fall into the risk category, and also the buildings that currently aren't in place, such as hotels and so on. I think there is also scope for those to be in the mix. So I think taking a proactive and preventative approach really is key, because then it'll prepare you for some of the changes that might well occur in the future.
Brilliant. Thank you, Kizzy. Last question for you. Are leaseholders accountable persons? And if so, do their details, including address, email, etc., have to be displayed in the communal area?
In the communal area?
Yeah. So I think the main, you know, like the PAP details may have to be available. If leaseholders are the accountable persons, does their information have to be displayed?
Yeah, so leaseholders are accountable persons. I don't think all leaseholder details have to be displayed. I think PAP details, yes, which is why. And again, you can also have PAP, but you can also have a nominated person as well who can be contacted. I think it would be unreasonable to have all leaseholder details displayed. So I think it's really PAP and the one that's contactable for the purposes of communicating with other RPs and the regulator. That's the requirement.
Brilliant. And David, last question for you. What do you think is happening regarding annual reviews of fire risk assessments? Do you think you'll be required to complete a new fire risk assessment or just a desktop premises review?
Well, that's very interesting, because actually within the code of practice, it is actually talking about, in certain areas, the frequency of fire risk assessments. I certainly know that again, we've got these two regimes here. We've got a potential code of practice, and then we've got comments that we've heard from the regulator. Now, the regulator has, in some instances, intimated that they are certainly looking for an annual review in the early stages of this process. But again, that's nothing in writing. It's purely anecdotal. But the code of practice does talk about the fact that in some areas you may be able to, depending upon the level of risk, depending upon the level of remediation required, and mitigation activity that is necessary or has been identified, you could maybe extend the fire risk assessment frequency out 18 months, 2 years. Again, it is nothing that's actually set in stone, but again, that is really where we're looking at the moment. There is a potential to move it out in the longer term.
Brilliant. Thank you, David. Thank you to everybody that has attended today's webinar. I can still see a number of questions coming in. So what we will do is we will take them offline and issue a frequently asked questions alongside a copy of the webinar for those that are interested. Just before everybody logs off, I just want to kind of highlight to you our next webinar that we're offering, which is the 4th of June, around building assessment certificates and what you need to know about the nuances and obviously becoming compliant with legislation. So again, big thank you to Kizzy and David for today. Really, really interesting. And thank you everybody that has joined, and we'll see you all soon. Bye-bye.
Everyone.
Thank you.